Hey soldiers, we have a major decision in the cryptocurrency world, one that may add some clarity and confidence to that whole industry, to that whole sector. Now, as you guys know, I have been very reluctant to jump into crypto simply because of the lack of regulatory clarity on the one hand, and on the other hand, I still doubt if the United States is going to give up this war against crypto. We've done plenty of videos about how the United States Senate, the Congress, the regulatory agencies are all banded together to quash crypto and to make it fall under this regulatory rubric that is so labyrinthian that, there's very little clarity or confidence in it. So that whole ideal took a major blow here on yesterday with the Ripple decision, the Ripple XRP decision. We're going to go into that. Now, this doesn't just affect Ripple XRP. It, no pun intended, ripples, or let's just say reverberates throughout the industry, and it's going to also affect the Coinbase litigation that is going on. So let's cover this. You know that I think if you watch the channel, you're well familiar with my feelings about crypto. And I've laid them out very succinctly for you. I thoroughly understand and really like the concept of crypto. But again, you got some major governments fighting hard against this. In any event, XRP has jumped in value in the wake of this decision. Guys, go ahead and hit the subscribe button. Become a soldier of finance. Enlist in this army. We will make sure that you stay informed, aware, and receive actionable intelligence on how to navigate this rapidly evolving global economy. You don't want to be left without a seat when the music stops, right? So go ahead, hit subscribe. Listen, you guys do a wonderful job of hitting the thumbs up. Go ahead, do that for me, and hit that join button. If you're not a member here with our members exclusive videos and community post, and you definitely want to correct that. Hit that join button, see what we have to offer. All right, so the Ripple case has gotten a victory. I don't think you can classify it as anything but, although it is kind of a split decision. And so just as a little teeny bit of history, you know that Ripple has been in litigation with the SEC, who brought the case, charging that the Ripple token is a security, okay, or the XRP token rather is a security, and Ripple had argued against that. Ripple Labs scored a victory in the United States District Court in the Southern New York District today, as Judge Analisa Torres ruled in favor of the company in a case brought forth by the SEC dating back to 2020. Now I'm reporting this the day after. And I like to do that because there's more clarity as the hours go by, okay? We'd rather be accurate and, give you a fuller account of what's going on than be first. According to documents filed on July 13th, Judge Torres has granted summary judgment in favor of Ripple Labs with regard to whether Ripple XRP token is or is not a security. Now, if this had been adjudicated as a security, then it would have fallen under a tighter regulatory framework. And remember, guys, regulation tends to quash creativity. It tends to be very expensive, all right? So the United States government has several tools in its war on crypto. Regulation and legislation being chief among them, and then the law, okay, fighting these things in court. So those are three very powerful tools that they use. One seems not to have gone their way in at least this case for now, because there is a chance that they're going to appeal this. The judge ruled, they being the SEC, Securities and Exchange Commission, the judge ruled that the XRP token, quote, is not necessarily a security on its face, unquote, except when it was sold to raise funds from institutions. The SEC lawsuit sought to compel Ripple to stop offering its XRP token under the premise that XRP was a security and thus required additional regulation. So the judge is saying in large part here that, and we'll see, when this thing is sold to, individuals, that it's not going to be considered a security, and there's some more, nuances here. Per court documents that were viewed by the publication Cointelegraph, quote, defendant's motion for summary judgment is granted as to programmatic sales. That's retail sales, mom and pop investors, you and me. The other distributions and Larson's and Garlinghouse's sales, and denied as to the institutional sales. So let's just go over that. So they're saying that the founders, co-founders, CEOs, Larson and Garlinghouse, the programmatic sales, the retail, mom and pop sales of the XRP token, and other distributions are going to be thought of as not securities. Okay. But with regard to institutional sales, the court is denying the motion, meaning that those institutional sales will be looked at as securities. Federal District Judge Analisa Torres ruled that programmatic sales to public buyers and distributions of XRP to Ripple Labs employees did not constitute the sale of unregistered securities. The court did not address secondary market sales of XRP on cryptocurrency exchanges. Now, that's important because you also have the Coinbase suit that's going on out there, and Binance, the SEC, is charging them with those organizations with selling unregistered securities. So Coinbase believes that this ruling here is key to them winning their suit, or the SEC's charges against them, being victorious in that case. But keep in mind, the court did not address secondary market sales or XRP on cryptocurrency exchanges. But even though they didn't specifically address that, if you're saying that certain sales of the XRP token are not securities, then that definitely would seem to boost Coinbase and Binance's arguments. And those cryptocurrency exchanges still are under a boatload of scrutiny because of Sam Bankman-Fried and the whole thing going on with the criminal charges in the FTX scandal. So that put a black eye on the cryptocurrency exchange industry. So this would be good for them if they're able to rise above it and kind of use this XRP ruling to help them do that. Institutional buyers who directly purchased XRP from Ripple had a reasonable expectation that their investment would contribute to improving the XRP ecosystem and increase the value of XRP. Okay, so those are the institutional buyers. However, programmatic buyers, the broader public, accounted for less than 1% of global XRP trading volume, and the sales were blind bid-ask transactions where buyers could not have known if their payments went to Ripple or any other seller of XRP. The court further noted that Ripple did not make any promises or offers concerning programmatic sales, okay, as the company did not know who was buying the XRP token, and the purchasers did not know who was selling it. This provides much needed regulatory clarity for the cryptocurrency industry and clarifies the legal status of XRP. However, the SEC may appeal the decision, which, I think they're going to do, keep this tied up for a little while longer. Because remember, the court of law, adjudication is another weapon of the, United States government that they're going to wield in this fight against crypto. Why are they doing this? Well, because if you were the arbiter of the currency, okay, you're the United States government, or any government for that matter, especially if you're the government that holds the world's reserve currency. A world reserve currency right now that is in flux. We've covered extensively how the dollar right now is suffering a death by 1,000 cuts as all of these different nations move away from the dollar in some way, shape, or form, eroding its hegemony. So if you're the United States government, you definitely don't want homegrown dissent like this from the crypto world. But it may be a futile battle in the long term when we look at what the governments are trying to do. Okay, so summary judgment is a split decision, okay? And we talked about that. We alluded to it earlier. The crypto, in that they ruled that the crypto token sold to the public may actually be a security when sold to, that same token may be a security when sold to other people. So I like the way, or other larger organizations, I like the way Zero Hedge put this, that they're saying it's a Schrodinger security. Now, if you're familiar with Schrodinger's cat from physics, I won't go deep into it, but the cat is both dead and alive until it is observed, okay, inside the box. There are plenty of videos on it. This is not the place for it. It'll drag out the video because I love the subject so much and I'll get passionate about it and go off the beaten path. Look up Schrodinger's cat. Schrodinger's cat on YouTube. So crypto is a Schrodinger's security. It depends on who's observing it. The bottom line is that this ruling appears to offer a lot of leeway in the interpretation of whether a crypto token is a security. Furthermore, the court's decision to cite the Howey test to determine whether XRP sales constituted investment contracts is a major blow to the SEC. The judge concluded that the SEC had failed to prove that XRP sales met the criteria for such contracts. All right, and of course, the XRP token value shot up in the wake of the decision. You could take a look at it. That thing is so volatile. Whatever I give you right now is going to be absolutely inaccurate when you watch the video. So you can just take a look at the value of it if you're interested. Now, if we slide over real quick to the folks at Coinbase, they've watched this and they're saying that they believe this is very positive for their case against the SEC, the case that the SEC brought against them.
But for exchanges, for tokens that are listed on exchanges, for regular investors, there's no question that this ruling strikes a blow to the idea that somehow securities are being traded when people go onto exchanges and trade the assets.
So, Paul, you've got the ongoing case right now with the SEC, which has accused you, of course, of selling unregistered securities as well. Do you win now?
I think we will win. Now, I thought we would win before this decision. We think this decision has only further strengthened the case. And the reason is this was not just a casual opinion offered as part of a much wider dispute. This was an opinion that focused on the key issue in our case and in many other cases, which is, are these tokens, when they are traded on exchanges, securities transactions within the meaning of U.S. law? The judge spent dozens and dozens of pages analyzing each of the underlying issues. She took a long time in order to reach her ruling, but I think that all reflects care. I think it all reflects deliberation. And her reputation as a thoughtful jurist, I think, will also carry great weight for other judges looking at similar issues.
I want to just touch on just how this will help long-term, and I know I spoke about impact long-term, right? But as your business sort of looks at this, how much does this paint the view then for the likes of the SEC and other regulators to really firm up when it comes to their regulation around these, whether it be what they deem crypto tokens or the like, and really have a more succinct basis of how to rule on this? Because clearly this is going to create a lot more arbitrage, yes, but really a difficult situation in which to trade in.
Well, I think this was an important milestone event in the somewhat tortured history of cryptocurrency regulation in the United States. If nothing else, I think it's underscored the reality that we need clear rules. We need to have standards set out through a thoughtful consultative process, much like the one that here in the UK is underway. The contrast between the approach the UK and Europe has taken to setting these standards could not be greater with what we've seen in the US, where unfortunately our Securities and Exchange Commission has relied upon court cases and litigation rather than consultation and rulemaking.
Now, as you might recall, Coinbase was sued back in June. We covered it on charges of operating an unregistered brokerage and exchange, but you just heard from their legal counsel, Paul Greenwald, on his thoughts about where this goes from there. Part of Coinbase's optimism stems from the decision regarding XRP not being a security. If XRP isn't designated such, there is hope that hundreds of other cryptocurrencies will also not be subject to securities law. But, you know, we did have part of the judgment that did say that under certain circumstances, XRP would be considered a security. So then, and again, I'm no lawyer, but I've watched enough Matlock to kind of surmise that the sales of the tokens to institutions under this ruling would still be considered securities. So there may still be some exposure for Coinbase and Binance to the extent that they do business with these larger institutions. Okay, not just the mom and pops. Whether or not crypto assets are securities is an important question with several implications. If they are deemed securities, then they would need to register with the SEC and would have strict disclosure requirements. It would also give the SEC the power to oversee these assets and related firms such as cryptocurrency exchanges. So that's the exposure here. The SEC has maintained that most cryptocurrencies are securities, but the decision on XRP appeared to weaken that argument. Guys, this is far from over, okay? This is going to linger in the courts for a long, long time. Lawyers are going to be very happy with this. The crypto industry has had heated words for the SEC over the past few months, accusing the agency of regulating by enforcing rather than by working with the industry. Excuse me, Tyler Winklevoss, the co-founder of cryptocurrency exchange Gemini, that is also subject to an SEC lawsuit, called the regulator a failed institution. All right, so Coinbase's Greenwald said he did not think the SEC was waging an ideological battle against the cryptocurrency industry, but that all actions were done in good faith. However, he added, they have been wrong. All right, so there you have it. Again, we're going to continue to follow this because we know that it's going to stay out there for a long, long time. We know that with a high degree of certainty that this thing is going to be appealed. Now, going back to what I was saying just a few moments ago about the dollar being under threat, and that's one of the reasons why these regulators, legislators, and legal authorities here in America and other countries are so focused on quashing crypto. One of the reasons for that is covered in this video right here. Look at what the BRICS nations are doing. They are going to be announcing something very big very soon, and it's going to constitute an immense threat to the dollar's continued status as the world's dominant currency. Check it out. Guys, I'll talk to you soon.